I'm Mark Schroeder from GSHC Surrogacy Agency. Today I'm speaking with Greg Masler, a surrogacy attorney from the law offices of Gregory S. Masler, to discuss the surrogate side of the legal aspect of the surrogacy journey. Greg, how are you doing today?
Very good. Thank you, Mark.
What does a surrogacy attorney do?
So a surrogacy attorney's role in the surrogacy process is essentially regarding drafting and reviewing the surrogacy contracts between the intended parents and the surrogates. The surrogacy attorney also is involved after a pregnancy is confirmed in preparing and reviewing documents that will be filed with the court, which we call pre-birth order documents. So it's essentially negotiation and review of the contract, as well as making sure that the documentation that's filed with the court is proper, so to establish the intended parent's parentage over the child.
What is a surrogacy contract and why is it important?
A surrogacy contract is very critical because it documents the relationship and the responsibilities and rights of the parties with a gestational surrogacy arrangement. It's important because it documents the fees and costs reimbursements for the surrogate. It documents the medical costs, how medical costs are going to be paid for during the surrogacy arrangement. It also documents other very important things about it, such as parentage. Who are the parents of the child or children that the gestational carrier will be carrying, as well as other things such as the escrow account. How much will be deposited in escrow, how much will be paid out, dispersed from the escrow account.
What say do surrogates have in the drafting of the contract?
The surrogacy contracts are critical because they address the parties' rights and responsibilities, including those of the surrogate. And it's going to be very important that the surrogate, when she signs the contract, that it includes verbiage that she feels comfortable with respect to their rights and responsibilities. The surrogates do have a say about what goes in the contracts. They are a negotiated instrument, and the surrogate's attorney would be consulting with the surrogate prior to the contract being signed off by the parties, and she will have input on any kind of revisions or changes she would like to have made to the contract.
How can a surrogate protect her privacy?
The privacy of all the parties, not just the surrogate, is going to be a critical component of the contract. The contracts include what's called the confidentiality provision, which lays out very clearly that the surrogates and the intended parents should not be sharing the identities of the other party with anyone else without their approval. This is something that I focus my consults with surrogates about the surrogacy contracts. I focus in on that and I explain this is something that is very important. Even if the parties do feel comfortable with each other, have a good relationship, which I would anticipate that they will, still, this is something that they should be communicating about even during the course of the arrangement to make sure that they are not disclosing things inadvertently even to other people. So the contract will document this, what we call confidentiality clause, which, by the way, also extends to, in very unlikely circumstances, there were litigation. The contracts have a clause that say in the case of litigation, the parties will ask the court to actually seal records and issue what's called a gag order to prevent the parties from discussing their arrangement with the press or anyone else. As far as any kind of other privacy type of issues, such as between the parties after, let's say, the child is born, the contracts do reflect that any communication between the parties after the birth of the child is voluntary, and that at any time, if any of the parties request that there be discontinued communication, then that will happen. So the contracts recognize that there may be ongoing communication after birth of the child, but it's not required, and it cannot be forced on either surrogate or intended parents.
What happens if a surrogate or intended parent doesn't follow the contract?
Well, like any contract, the parties may sue each other. We hope that will never be the case. This is something I think extraordinarily rare, and I'll just say, with my years of practice, I'm not aware of any of my clients that have been involved in litigation. No one's at least made me aware of that. So that's sort of the good news, if you will. But it is a contract, and should any of the terms be breached by either party, they could be subject to litigation, or at least a demand for fixing the breach, and potentially litigation.
What happens if a surrogate's marital status changes during her surrogacy journey?
It's a very good question. It's fairly often that the surrogates are not married when they enter into a surrogacy arrangement, or they may get divorced. So I'll speak from the perspective of a single surrogate, or a surrogate that may be in a domestic partnership or have not actually be legally married. In those arrangements, when I consult with surrogates, I make this very clear that if a surrogate gets married, and there's no problem, of course, with the surrogate getting married, that's not an issue at all. But if she gets married during the course of her surrogacy arrangement, after the contract signed in particular, that she let her attorney, let the agency, and then I, in turn, if I'm her attorney, would let the intended parent's attorney know. This is going to be very important to add the spouse of the surrogate to the contract, because there are issues pertaining to privacy, confidentiality, even parentage of the child that should be addressed in the contract that relate and pertain to the gestational surrogate's spouse. And at the pre-birth order stage, this is very critical as well, because if the surrogate is married, her spouse would need to be included in the pre-birth order documents, documented as the spouse, and that the spouse acknowledges that the surrogate is not the parent of the child that she's carrying, and of course that the spouse is not the parent of the child that the surrogate is carrying. With instances where the surrogate may be in the process of separating or divorcing, this is something that's going to be important to let the attorneys know as well. It's going to be critical that those spouses sign what we call the pre-birth order documents that will be filed with the court. And it's a good idea that the parties and the attorneys are aware of the surrogate's particular marital status situation.
What happens if there are complications during the pregnancy?
If there are complications related to a pregnancy in the surrogacy arrangement, a good contract should reflect how the surrogate would be taken care of and how these issues would be addressed. If the surrogate, during the course of discussing the contract with her attorney, has any questions about compensation in case of any kind of, for instance, diagnostic testing, who would be responsible for medical expenses, she should most certainly be bringing these up during the course of her consult with the attorney about the contract.
Can a surrogate decide to keep the baby?
Well, I'm going to speak to California law, which again, I'm licensed in California and not any other state. And in California, the answer at the present time, the current state of law, is absolutely not. The contracts reflect that the intended parents are the parents of the child. And the law here in California makes clear that the intent of the parties with respect to parentage is what rules. So the surrogate could not keep the child.
What happens immediately after the contract is signed?
In the state of California, the medical protocol cannot begin until the surrogacy contracts are signed. Specifically, that there needs to be a contract in place between the surrogate and the intended parents before the start of the cycle meds and the embryo transfer. So once the contracts have been signed, the intended parent's attorney drafts what's called a clearance letter to the IVF clinic, informing them that the contract has been entered into between the parties, and then the IVF clinic can begin their medical protocol.
Whose names will appear on the baby's birth certificate?
The intended parents' names will appear on the birth certificate, and the contract itself unequivocally makes clear that the intended parents are the parents of the child. So this is going to be a very important aspect of the contract to be able to say who the parents are and ultimately whose names will go on the birth certificate. And this is addressed, that particular point is actually addressed in the contract. Later on in the pregnancy, after the surrogate is confirmed pregnant, there's a process that we call the pre-birth order process. And these are pleadings and court documents that are prepared by the intended parent's attorney typically. And usually, depending on the attorney, usually they're filed ideally around week 25 of the pregnancy, though sometimes a little bit later, sometimes a little bit earlier.
What contact will the surrogate and the intended parents have after the delivery of the child? This
is something that's voluntary. The contracts even reflect that the parties can or cannot decide on their own whether they'll have communication with the other party. And the contracts typically do reflect that if one party wants to discontinue contact with the other party would respect the wishes of the party that wants to cease contact communications.
I'm Mark Schroeder from GSHC Surrogacy Agency, and this has been a conversation with Greg Masler from the law offices of Gregory S. Masler. Greg, thank you so much for your time today.
Thank you, Mark. I appreciate it as well. Take care.